Okay, we're going to get started, everybody. Thank you so much for joining us. My name is Allison Korn. Can everyone hear me? And I'm Assistant Dean for Experiential Education at UCLA School of Law. I and Layla Halas would like to welcome you to our second session in the Teaching Justice webinar series. Today, the topic is Teaching Justice in the Context of Immigration, and it's presented by Annie Lai, Clinical Professor of Law and Co-Director of the Immigrant Rights Clinic at UC-Irvine, along with my colleague, Sameer Ashar, Vice Dean for Experiential Education and Professor of Law here at UCLA. This session should last about 75 minutes, but it might go a little bit longer depending on our discussion today.
And I'm Layla Halas. I'm the Director of Experiential Learning over here at Tulane Law School. I'm the co-chair of CLIA's Best Practices in Pedagogy Committee. And a project of this committee is this Teaching Justice webinar series where over the next academic year, we're featuring a number of innovative faculty who talk about different approaches to teaching justice in the classroom. Each session is going to draw on the wisdom of current resistance movement and examine its intersection with economic justice, immigration policy, criminal justice, racial justice, among other issues. And in fact, our next session is already scheduled for March 19th, 2019 at 2 p.m. Eastern Time. It's going to be with Deborah Archer, the Associate Professor of Clinical Law and the Director of the Civil Rights Clinic at NYU. And she's going to be presenting on teaching racial justice.
So for our webinar series, most of you have already muted yourselves, so thank you, but we will ask you to please mute your audio, or Layla and I can do it for you so as to be free from all distractions during the presentation. Also, we're asking everyone to please switch off their video function during the presentation. There may come a time when we will unmute you and resume video functioning, but for right now, we'd like the attention to be drawn to the presenters. Layla and I will be doing the same shortly following this introduction. And before I turn it over to Annie and Sameer, I want to provide some session-specific information before we hear from them. So first, just to let you all know, about 45 minutes into this presentation, we are going to be breaking up into small groups. If you are currently joining the webinar by phone, you might want to, if it's available to you, rejoin from a device or a computer that has video so that you can more actively participate in that breakout group if you choose to do that. You also have the opportunity to change your name tag to add the school that you're in. If you'd like to do that, you can hover over your name to rename yourself. I believe there's an option. Again, it's not required, but you may choose to do so. To view a list of participants in the webinar, there is a icon at the bottom of your screen that says participants. So you're welcome to look and see who's joined us today. To use the chat function, you can, again, there's an icon at the bottom of your screen marked chat. You can select who you want to send a message to. I believe right now it's only to either everyone or to the host or co-hosts, but you are able to do so if you want to pose a question to the group or if you're having any technical difficulty. That's a lot of information. So before we do break into small groups, you will be getting more specific instructions along the way. But Layla and I are here to serve as your administrator guides, so please don't hesitate to reach out via chat or otherwise. And enjoy the presentation.
All right, can everybody hear us okay? Okay, great. Good afternoon, everyone. My name is Annie Lai, and I'm so excited to be presenting this webinar today and to have this conversation with all of you. And I'm also excited to be reunited with my former co-teacher, Sameer Ashar.
Hi, I'm Sameer Ashar. As Allison said, I'm at UCLA Law, where I'm the Vice Dean for Experiential Education and teaching in the Immigrant Family Legal Clinic this year.
And so we are going to go, because our faces are a little bit small, into our PowerPoint presentation now. So it'll just take me a second to do that. What we wanted to, when we were thinking about today's webinar and thinking about what we could focus on for the next 75 minutes, we reflected on the fact that, you know, at this time in the Trump era, the call to do the work that we do in immigrants' rights is greater than ever. And there has been, you know, discussions about what clinicians should be doing at this time. Some clinicians are going in different directions on their docket and in their seminar. The outcome of the reflection that Sameer and I did right after the election in 2016 largely landed us in terms of docket and seminar back where we had started. But that was an important process because it helped to reaffirm the choices we had previously made about what we want to do with the Immigrant Rights Clinic at UCI. And so that's what we're going to spend today talking about for about 45 minutes. But we hope that our kind of candid reflections on the choices we've made, particularly in the clinic seminar, might spark some conversation in the small group breakouts for you all to start thinking about your clinics in this time.
I think we, I mean, this is a especially one-way form of exchange, which both of us are sort of uncomfortable with, as everyone is muted, which usually isn't the case in a classroom, obviously, particularly in smaller clinic seminars. But we're going to try to make the best of it, and you know, hopefully the breakout groups allow folks to share with each other and then eventually share with the entire group, because we believe that the wisdom is, you know, obviously in our collectivity, and all of you who have signed up to listen in today. So we're looking forward, again, to some form of exchange, and then over time, through when we meet, when we are at conferences together, through email, you know, we hope that this is part of what CLIA is trying to do, is create communities of teachers, and so we really appreciate the opportunity. So just to give you a little bit of context about Annie and I, we co-taught the Immigrant Rights Clinic at UC-Irvine for 5 years, between 2013 and 2018. Some basic mechanics on the clinic that may or may not look like yours. So we want to be conscious of the differences, and particularly of the freedoms that we've been afforded through structure and through leadership at Irvine, as opposed to other people's contexts. So we have both constraints, but we also have freedoms, and I'm sure that's the case for everyone who's participating in the webinar. So the Immigrant Rights Clinic is a one-semester clinic. But it's offered every single semester. It's offered for 6 units. All of the core clinics at Irvine are offered for 6 units. Ours is one of them. The IRC was one of them. The clinic is required at Irvine, so we have a regular flow of students into the clinic. Nearly every semester we have some mix of 2Ls, 3Ls, and returning students, you know, and could be either 2Ls or 3Ls. And
yeah, so our student body tends to be traditionally progressive. There are a lot of students interested in public interest and government service. But it's still mixed. In contrast to the more progressive leaning student body that we have at UCI, we are working in Orange County, California, in a historically conservative context, despite the county being 1/3 immigrant, and it's the 6th largest county in the country. It is still controlled by political conservative elites, despite the very exciting results from the midterm elections, where we were able to flip a few districts.
I would say one other sort of contextual piece is that because of the the conservatism of the political firmament in Orange County, the organizing is really, really exciting, but it's kind of nascent and fledgling. And really, in the in the 5 years that we talked together, we really saw the flowering of a small group of organizers in the immigrant rights community, you know, centered in Santa Ana and Anaheim, trying to affect change. So that's been that was a real exciting part of the work that we're doing. But that's a reality. We know that folks are in lots of different kinds of contexts, conservative contexts, high organizing contexts, low organizing contexts, but we hope that we can try to sort of pass on something that's useful to everyone.
Great. So as I mentioned before, let me just get to the next slide. As I mentioned before, what we're going to do is to share with you a little bit about our clinic seminar. We're going to take apart our syllabus. And the idea is we're going to talk generally about our syllabus, and then we're going to get to a set of classes that Sameer and I would regularly teach every semester, no matter what was going on, to help our students deepen their understanding of justice and what it means to work towards justice. And we have some theory behind the approach that we took, so we'll go through the theory and then hopefully get to show you exactly what we're doing in the clinic.
Just in terms of background, as Annie indicated, we thought critically about what we were doing after November 2016 election of Trump, but really the way we've been thinking, particularly about the justice arc, really predated November 2016. And Annie, as all of you as immigrant rights advocates and activists know, the work before Trump, the work was bad during the Obama years as well, and even before that during the Bush years. And so, in terms of the context generally of legal education and immigrant rights advocacy, what we've really tried to do is kind of more in the way of kind of some continuities and then some discontinuities to adjust to the new context. But in terms of the legal education context, a few things that we would like to share about, like the theory behind what we're doing. One is that we are really resistant to calls in legal education, particularly in the last 10 years or so, 10 to 15 years, to try to extend practical skills education at the expense of social justice values. So we're pretty explicitly opposed to that. We don't think that you can work in community without really thinking about social justice and the ways in which clients that you may be serving are systemically subordinated, and the ways in which systems sort of commit legal violence against the client populations that we work with. So doing valueless practical skills education was not something that we were ever going to do, and it's something that we resisted as we tried to figure out how to integrate our students for practice, but at the same time, we also wanted to keep a kind of critical social justice arc in the work that we're doing. The other thing that I think we're doing, particularly during the Trump era, there's been a big push, particularly in immigrant rights, for more lawyers, more cases, and we're supportive of that. We're supportive of universal representation strategies in Orange County and in other places. But we are we kind of seek to challenge the idea that even in this era that social change and social justice will be done in a way that's lawyer centric. And we co-wrote a short piece together that's a critique of the Access to Justice movement that's going to be coming out in January. And that really describes kind of the approach that we tried to take in the Irvine clinic. We try to embrace kind of another dimension of law. So there's the kind of individual students working on individual cases representing clients, say, in bond proceedings. That's kind of what we would think of as first dimension lawyering. We think that's really important. We try to do that in our clinic. It's a key part of our docket. Every student in the clinic works on a bond case and in teams with other students. But then we also think about second dimension lawyering, that is working on policy advocacy projects, that is community has ideas about ways in which they're trying to do social change in the communities that they're in, and they come to lawyers for support. Lawyers help draft legislation or help prepare community constituents to advocate for those policy changes. That's what we think of as sort of second dimension lawyering. We also really aspire to do third dimension lawyering, and you'll see that kind of embedded in the justice arc in our syllabus. that is helping to build the capacity of communities, working closely with organizers to identify problems and solutions, really that are far below the surface. And some of you will know that this first, second, third dimension framework is straight out of Lucy White, Lessons from Dry Fontaine, and informs the way in which we construct our docket, and then the way in which we also construct our syllabus to try to speak to these different dimensions of learning and ensure that our students, have ways in which to access learning about all three dimensions of learning.
Thank you, Sameer. All right, so we're just trying to figure out a technical issue with the PowerPoint, but hopefully you guys can see the next slide we're going to, which is sharing our syllabus at a glance. So what we want to do here is, what you see on this slide is basically all of the topics that we pulled out from our typical semester syllabus. So you could see, the whole semester. And on the next 3 slides, we're kind of highlighting different types of seminar classes. Oftentimes, at the clinic conference, you hear people talking about a particular learning activity or a particular class that they've designed, but we rarely get to see the entire semester's worth and how something fits in. So we wanted to share that with you. So our syllabus at a glance, the first slide right here is the whole semester. The classes highlighted in blue are what we see as our skills arc over the course of the semester, starting from the left-hand column all the way to the right-hand. And you can see that a lot of these probably are similar to skills that you all are trying to teach in your clinic seminars.
So the second slide, this next slide, taking apart our syllabus, focuses on knowledge bases that we're trying to share with our students. I think this is a particularly fraught kind of area. That is, we try to be trans-substantive in that we're doing lots of, other than the bond cases, which all students do, we're working on projects in different areas of the law, at the intersection of criminal law and immigration law, at the intersection of immigration law and employment and labor law, and we bring in lots of different sort of sources of knowledge. But what you see on the slide that was just up before this one is our attempt to try to meet student demand for more substantive education. I think every semester students say, we wish we knew more at the beginning of the semester before you threw us into the work in week 2. And, as others will know, who are part of this, who are listening in, that's kind of part of the attraction of clinical education, to throw students in and get them to work on things and learn things together, particularly if the cases differ and the clinic is trans-substantive. So we do really a minimum amount of knowledge development, which maybe is what creates the room to do some in-depth skills work and then a lot of kind of critical justice work.
Okay, Layla, you wanted me to stop the share, right?
Yeah. Once I get the PowerPoint, I can share it, and then hopefully we can move through it a little more seamlessly. Thanks.
Okay. Apologies, everyone, for having some issues with the PowerPoint, but we will keep going. And once the slides come back up, we'll try to talk through until the slides come back at what we're sharing. So the next slide is going to show our syllabus, but with our justice arc, our series of classes again that we hope introduce students and help them think more critically about justice, and in particular the role of lawyers and law in achieving justice. Those classes, we're going to take a few of them and dig a little bit deeper and show you what we actually do in those classes. But to kind of talk through them in a general sense, Where the first one that's highlighted is the introduction. So Layla, you're going to go to slide 6. Next one. Great, perfect, thank you. The first one is an introduction to our clinic. We put this on the Justice Arc because that is really the first day of the semester when we introduce students to our docket and our mission in the community and our pedagogical mission in the clinic.
We'll drill down a little bit in a few minutes on lawyer-client relationships, which is the next class in the Justice Arc. The third sort of thing we do, or the major thing that we do, is we describe as immigration legal history, and as well as a discussion of multiple consciousness. And the idea here is both to give students, particularly those students who don't have the benefit of an immigration law class, we don't have a prerequisite or co-requisite, some understanding of the system that we're entering into, the immigration legal system, the underpinnings of the immigration legal system. But what we think we do that maybe that has been great for us and that we really appreciate and enjoy, and we hope the students have as well, is going into immigration legal history. So going back, using the work of other scholars, immigration law scholars like May Nagai, and as well as others, to really shed light on kind of, again, continuities and discontinuities in immigration legal history, so that people don't approach current problems as if they're not linked in some ways to kind of trends that have occurred and sort of patterns of subordination and sort of go-to moves made over time, over hundreds of years. We think that it gives students both some relief from the idea that we are in an unprecedented situation in a moment of crisis, as well as some ideas with regard to strategies that can be taken. It kind of opens up our understanding of what we can do to take on the challenges of the current moment.
Okay, so the next few classes in our Justice Arc, going down to the bottom of the left-hand column, Legal Services, Scarcity, and Case Selection. This is a class that we do basically to introduce students and help prepare them for the fact that they're going to be they will have done a number of intakes by this point in the semester, and they're going to be making hard choices with respect to which clients we will be able to offer representation to, particularly for bond representation for detained immigrants for the rest of the semester. And we think that this, as with any of the classes in the Justice Arc, it's important to have kind of context and political understanding of the way the legal profession is structured, the types of cases that are a little bit more sympathetic and easier for somebody to find representation, the types of cases that are harder for lawyers to take, and therefore where the clinic might be able to make a more substantial impact. We've just added a reading that we think is important on this, which is about bias in the public defender context, that will help students think critically about perhaps their own bias when meeting with potential clients, and try to be mindful of that when they're making decisions about which clients are kind of deserving of representation.
Just one word about this, which is this is an example of a really challenging situation and context. Our students go in and they do intakes in detention centers, and they come back with like 6, 8 cases, and they have to decide how to prioritize these cases, which cases to take for the semester for their team of 2 to 4. And so we're really trying to take advantage of what Fran Quigley calls the sort of disorientation and the difficulty and maybe the conflict between the students about what they feel about the different cases, who they think is deserving, what needs to be done systemically versus which individual stories were presented to them and believable to them, what they think will be persuasive to fact finders. How do you take all of these complex factors and put it together and then decide on a docket? So even though we have limited role for students in the overall docket, in this part, when we're choosing cases, there's some room for student input and autonomy, and that gives them the chance to struggle with these issues that they're going to face as lawyers, we hope, in practice.
Okay, the next class on the right-hand column is law and organizing. For that class, what we usually do is invite organizers in the local community to come and talk to our students about experiences they have had, good and bad, with lawyers partnering in movements for social change. It's important for the students to hear the bad experiences so that they can hear firsthand the types of practices, perhaps norms, assumptions that lawyers often bring to a particular social problem that they don't want to hopefully replicate. And it's important for the students to hear about good and positive experiences collaborating that the organizers have had collaborating with lawyers, so that they can use that as a springboard for kind of developing their own vision of collaboration with their local organizers. We often pair that with a class with a discussion on group representation, because our clinic's representation of groups in the community oftentimes takes the form of collaboration on a campaign or a collaboration on a broader social issue with that community members are trying to tackle collectively rather than individually. And so the two discussions kind of pair nicely into a single class. Moving down in the right-hand column, we have fact investigation. And the reason why we include this on the justice arc is because we don't want the students to take away a notion that skills is separate from their justice education. And with respect to our fact investigation and the ethics classes, here we do teach a lot of substantive information and skills, convey skills training material in these classes, but we're also, for example, in the fact investigation class, assigning Jerry Lopez's some material from his rebellious lawyering text to show students that when they're going and doing an investigation, it's so important to know about the context and the community where the problem arises, or for example, in an individual case, the family context, the experience of that individual trying to overcome poverty, etc. So fact investigation is not just kind of a dry skill in the way that we envision it. It's an opportunity to further instill an appreciation for the work in service of social justice as they're doing their fact investigation. All right, immigration policing is somewhat self-explanatory. It is an area that I think as immigration lawyers, we don't often focus on. If we're in immigration court, we're gonna be focusing on forms of relief from removal, but so critically important for our students to understand better how our clients are ending up in proceedings, how they're ending up arrested in the detention centers.
I mean, this is the thing that we hear over and over again, which is that lawyers' intake forms often just start with our clients in proceedings and don't go further back. I'm sure others who are on the webinar are familiar with this, and this as a critique of the way in which we approach our cases. And so we're trying to bring into the core sort of syllabus the idea that students need to think about how individuals have entered into the system, even reaching back to any criminal legal history. Obviously, we teach about that, about using criminal legal documents. It's all relevant, particularly in bond proceedings, but in all post-conviction work as well. But here we're really trying to bring a critical lens to the way in which the populations that we're working with are subject to subordinating forms, patterns of policing in heavily over-policed communities.
Policy framing and media advocacy, again, are skills, but important skills for our students to have if they're going to be working on community organizing campaigns or policy issues at a more systemic level. What we do in the policy, the reason it's part of our justice arc in the policy framing class is we talk not only about effective and persuasive ways to frame policy issues, but the importance of messaging to different audiences, and in particular, if you're working with an impacted community, how messaging might look different and might be reflected differently in, for example, press releases and quotes in a press release, if you're coming from that angle as a policy issue. Counter narratives is a class that we don't always do, but it's always turns out to be really valuable when we do it. And the idea here is we draw on more traditional forms of narrative theory literature, like from Tony Amsterdam, that many clinicians use. And we talk about, because that narrative theory literature relies on stock stories, students kind of learning to use stock stories to persuade juries and decision makers. We talk about the importance of developing counter narratives, so that the narratives our students are building on behalf of our clients are actually challenging stock beliefs and stock stories and stock conventional understandings of why people do things, for example, or the context, in the broader context in which our clients are making decisions. So the counter narratives class, which our adjunct Emmy McLean, who we've worked with for many years at the National Day Liver Organizing Network, looks at ways that stories are told by activists, by community members in other parts of history around the world, and in other parts of the world, to draw inspiration for how we tell counter narratives can actually change people's understanding of the world.
I think this is a really important counterpoint class to the three classes you see above from the skills arc, case theory, narrative theory, as Annie said, trial ad 1 and 2, and fact evaluation. Because all three of those classes, again, is sort of just emphasizing what Annie said, rely on what we understand and what we think judges, hold, or juries, or, agency officials hold to be the stock stories that we need to build our cases around and have our clients fit into. And this class is really cool, and it's cool that, Emmy developed it with us because it challenges the box, basically takes us out of the box. Yeah, I mean, we're going to drill down on race, power, and subordination in a few minutes. And then, maybe you can talk about Trump stewardship, sustainability. Oh, right, we're going to drill down on that one as well. Rounds is really, I think, is it blued in all three? Yeah. So, as everybody knows, I'm sure, rounds are really, can be exciting and interesting. And one of the reasons it is because these three arcs end up colliding in rounds in a really awesome way. And from week to week, we don't know what's going to be brought to the surface. We have some ideas, but then we see what happens in the course of the class. And so the rounds, discussion of a particular case can focus on a strategic tactical issue involved that we're trying to get at through the justice arc. Or it might help students teach other students about an area of law that they've had to learn for their case that others don't know. So it also has relevance with regard to the knowledge arc. So I think that's probably an article waiting to be written. Those three arcs in the context of rounds. But we love rounds classes. We try to do as many as we can without exhausting the students.
All right, Layla, can you go to the next slide? All right, thank you. So we're going to drill down, like Sameer mentioned, on 4 of the classes that we do. The first one is lawyer-client relationships, is early in the justice arc.
So what we're trying to do here is denaturalize the interactions between lawyers and clients, right? We want our students to be intentional about the relationship that they're building. And I think, one thing that's key that we try to get students to take away is that it's a relationship, right? It's not an intake interaction. I mean, it could be an intake interaction, but in most cases, it's the initiation of an ongoing relationship between lawyers and clients. And it's a relationship that clients really don't want to be in most cases. Even in the employment context where we're prosecuting cases against bad employers,
it's not like a worker wants to be litigating to try to get their back paid. They just would like to have gotten paid on time, right? So we're always dealing with, and then particularly that's the case in deportation proceedings, we're always dealing with reluctant clients who don't really want to be involved in the relationship with the lawyer. We need to figure out how to overcome that reluctance to some degree, how to build trust, and how to think about the relationship over time. The second, with regard to intentionality, is that intentionality is the other key word in that first point, which is to really get our students to refrain from just adopting local entrenched models of representation, either within a particular context of the bar, like in immigration lawyering. There's obviously strong kind of presumptive ways in which lawyers approach clients. You go to any immigration court, you'll see that, ad nauseum. So we're trying to denaturalize that stuff and get students to resist adopting just whatever their supervisor at their externship or internship does, however they do it in terms of relation to clients. And maybe even denaturalize the way we interact with clients, and to think critically about how any lawyer that they're working with, and then when they graduate, they're able to sort of formulate their own relationships. We're trying to get students to think about a sense of possibility, and we draw on Chen and Cummings' public interest lawyering framework in terms of models of the lawyer-client relationship. It's organized chronologically, but also it's organized dialogically in a way that is, there's conventional lawyering in the mid-20th century. Cause lawyering is in some ways a response to it, an attempt to elevate the profession away from the mercenary approach to a more heightened approach to civil rights and civil liberties. Client-centeredness is in some way a response to that. And in terms of getting, particularly lawyers who are doing public interest law to be accountable to their clients and to not replicate inequality and lack of dignity in those relationships. And then community lawyering is the most recent kind of wave that's responsive to the individualization of client-centeredness and the need for more collective approaches. We try to describe these models. We then we map it on a board, on a whiteboard. We have students volunteer examples of lawyers that they've come into touch with and put them on this spectrum. Where do they fit all over the spectrum, between the categories, across the categories? So we're really trying to get students to see that it's intentional, that it can be intentional, and that it should be constructed, and they need to think about that stuff. You want to say a few words about the retainer?
Yeah, so and then the idea, after we spend a whole class talking about kind of in loftier ways, these different models of lawyering, we try to help students connect the theory to the practice that they're going to enter into in the semester of clinic ahead. And this class, lawyer-client relationships, is pretty early in the semester. What we ask students to do is to take a kind of template retainer and a template memorandum of understanding if it's a project with a community partner, a community organization, and infuse the language of that retainer or MOU agreement with a particular vision of lawyering. And we ask them to do it with respect to a particular matter on our docket. So this is a way to introduce our docket, to send the message that our docket is varied in terms of the models that it embodies, and that even within a single matter, there may be different visions of lawyering that can be manifested in the way they approach the work. And the retainer and the MOU, these are foundational documents. They are documents that can be a tool for having a conversation with a client at the beginning of a relationship, like Sameer mentioned, in the creation of that relationship. So a wonderful moment to introduce a particular vision of lawyering that the students would like to embody. All right, the next class we're going to talk about is multiple consciousness. So here, as you may recall from the earlier slide, our multiple consciousness discussion is paired with our discussion on immigration legal history. And overall, our learning goals for this class are to provide students with context and background for understanding the system in which they will be working. And as Sameer mentioned before, certainly to explore conceptions of identity and race as they relate to the work the students will be doing. Because in immigration practice, race is everywhere and nowhere. We don't talk about it in our everyday practice, and yet it is everywhere in immigration law and policy and practice. So we want to be explicit about that and kind of model for students early in the semester that we should be constantly thinking about race. And then third, and this is where the multiple consciousness comes in, we want students to have some kind of framework for attaining this type of multiple consciousness that allows students to see, as Mari Matsuda puts it, to see the world from the standpoint of the oppressed, of the most vulnerable in our community. That students should be mastering the rules and the vocabulary of the system that they're going to be working in, and advocating in multiple fora and kind of honing their craft before a diverse array of decision makers, but without internalizing the logic of that system. In order to not internalize the logic of the system we're going to be spending a lot of time in, we give them this Mari Matsuda reading so that they can have a way to kind of shift back and forth between kind of being in the system, but also seeing the system from the outside. Hopefully as a way to prevent the students from going mad, going crazy, but also as a way for them to always, as a discipline, be seeing the system from the perspective of our clients and the communities that we're working with. And as an exercise in multiple consciousness to introduce the topic in class, we have students do a free write. We ask them to identify a moment where they felt tension between their feelings about what's been going on with immigration policy, especially today, with their role as a law student and a future attorney, and use Matsuda to help them navigate that tension.
I mean, this is an example of not teaching to the middle, but attempting to get to everybody where they are. So for, critical, social justice warriors coming to law school to try to figure out how to put their theory into effect, this helps them not go mad, as Annie says. But for others who came to learn how to be a lawyer, for other reasons, other than maybe social justice reasons, or because as a profession, this is a way in which to get them to think both individually and systematically. We think that obviously speaks to social justice education, but it also speaks to what makes a good lawyer. And what makes an excellent lawyer in any kind of context is, again, being able to go up and down levels. The other point I wanted to make about this class is just that we don't want to dehistoricize Matsuda's work on multiple consciousness based on W.E.B. Du Bois's work on double consciousness, and that's the roots of it. And so it's a way to make connections between people who have come before, great minds that have come before us that help inform our practice.
Okay, next is our class on race.
So this was a culminating class. It's now part of a few culminating classes at the end of the semester. Early on in the semester, we have students do court observation. So even though they're in courts, immigration courts, as practitioners, we also have them we have them go and do an observation in immigration criminal court, and we give them a list of possibilities for their reference, but they can go anywhere they want. They can go to agency contexts as well, and we give them prompting questions that get at issues of race, power, gender, other dimensions in the way in which power is exerted in these contexts. And we have them do that sometime during the course of the semester, and then they turn in memos before this class, and the teaching team is able to look at those memos. We're able to identify some themes coming out of those memos that we want to talk about in the course of the class. What we're really trying to do here is put their observations, and one word on why we have them do court observation in addition to fieldwork is the idea is they learn different things as observers than as participants. Obviously, when they're representing a client, they're incredibly nervous. It's hard to kind of bring a critical lens, except for your immediate emotional reactions to what's happening. And so it's important for us to have both of those lenses, for the students to have both of those lenses when they take in these practice contexts. We're trying to put in juxtaposition their observations and field work against a series of texts. And we don't have them read all of these, all of these articles, but Annie is a master excerpter, so together we've generated over time, it's been growing incrementally, but it's paragraphs from each of these, again, a set of great thinkers. These texts speak to different parts of this sort of system of power and the way in which the legal system does violence. Nye and Haney Lopez speak to the construction of and the racially subordinated construction of illegality. And Carbato, focuses the excerpts that we use from his work focus on de facto racial denaturalization and the production of surplus compliance. And that particularly speaks to us as lawyers trying to get our clients to fit into boxes that will get them out of detention through the bond process. Christopher Bracey writes about the way in which dignity sits beside subordination. That is, we accept that the system is subordinating, but that one way to counter that subordination is to try to focus on the dignity of our clients and the communities with which we're working. Motomura talks about the ways in which times in legal advocacy by necessity because of the structure of the law. Spade talks about legal violence done against vulnerable communities, particularly communities of color, and as well as LGBT communities. And Luban and Crenshaw from different directions get at I think it's a little bit far-flung, but to say the liberatory potential of legal practice. And Luban is a much softer version. It's not really liberatory, it's more about making a record in history so that future generations can kind of come back, even if you're losing, so that future generations, even the next half generation lawyers can come back in 5, 10, 15 years and attempt to build on work that you've done. But that gives some breathing room and a sense of relief to students that speaks to the core theme of our entire clinic, which is how to lawyer against subordination.
Great, and I think that class on race.
I think Layla is prompting us.
Yeah, she's trying to get us to go a little faster. Yeah. That's okay.
Thank you, Layla.
Thank you. I think the last class is really kind of gets at the core of at least what our goal was with our justice arc in the semester which is to get students to think to be excellent advocates, but to also get them at the same time to be thinking very critically about law and the legal system and the practice that they're about to enter into. And to find ways to still be a lawyer, to be an excellent lawyer, but to be doing it not reflectively, but intentionally and critically. Okay, so the final class we wanted to just give you a window into, and I want to thank my co-director from this year, Linda Tam, who's a visiting professor with us for helping to really further develop this class. We shift in this class to the more affective dimensions of social justice practice, and it's so important for our students to see that we're not just kind of sharing kind of intellectual theory and political theory about the work that they're doing, but to engage with their kind of personal reactions. And there's a diversity within our students of students who feel personally affected by the immigration policies, who are mixed status families, are undocumented themselves, or who have lived in low-income neighborhoods in Southern California, and students who are kind of coming at the issue anew, but also experiencing a range of affective responses. And maybe committed to social justice practice, but the idea is to really push every student a little bit further to be self-reflective about what's happening and their reactions to what they're seeing. So the idea here is to really treat sustainability as a form of resistance, and to take that seriously, and that includes being good stewards of our own trauma, as well as the trauma experienced by the clients and the communities we work with, to take self-care seriously so that we can be whole people as we approach individuals and communities that we're walking alongside of, and to think about practices that will allow us to do the work for the arc for the length of a career and not just a year or two, kind of as a with a pro bono case occasionally. And it's particularly important for those of us who are have committed to working in an area like immigration and in a particular subset of immigration cases, folks who have a lot of criminal history involvement, criminal justice involvement, or in marginalized communities within the immigrant community, because we are going to be taking cases and causes that feel in the short term like losing cases and causes. And we want our students to be able to develop some resiliency from doing those over and over again and kind of not burn out. And in that way, they are committing to a form of resistance that will be decades long as opposed to a couple of years long. And we usually have students do a reflection memo after they read a number of readings on these topics. And one of the contributions Linda made this semester was to suggest that students could also, in the alternative, do some kind of creative piece. And a couple of our students took that up. I think one of our students wrote a poem, and we had kind of other formats for their reflection. All right, I think next slide. It's now time to shift, start to shift to the breakout discussion. And the idea is that we want to, now we've shared, kind of our theory and what we're trying to do, to talk a little bit more candidly about some of the tensions and challenges associated with having kind of a justice arc alongside the kind of skills and knowledge arc.
I mean, neither of us are like jazz heads or anything like that, but I just found this, and as we were working on preparing this presentation, I sent it to Annie, it clearly spoke to both of us in terms of what we're trying to do with the justice arc, which is to develop a kind of critical counterpoint to the formalistic legal practice. If we regard that as point, then counterpoint is the justice arc, and I think also to bring to bear to the study of law histories and voices of people that are left at outside of the gates of the university, outside of the gates of the law school, potentially silenced even if they're able to gain entry. Sometimes in the form of theory or in the form of stories. We're attempting to bring, long suppressed stories and histories to bear on how our students are being inculcated into legal practice. We're trying to challenge the idea that there's one way to be a lawyer and that there is a set of skills that you get and then you graduate and you're a lawyer. And we're instead trying to show that legal practice can actually be much more exciting. It can be much more dynamic, and it can be much more organic and responsive. In terms of challenges, I'm sure we sort of look forward to the exchange with all of you, and I'm sure everyone faces challenges in trying to include some of these justice values. That's the purpose of this entire series. A few that maybe I'll speak to, and then you could. One is, how do we know what we're doing is effective or not? So the idea of measurement, teaching evaluations, of course, as we all know, is a kind of flawed mechanism. I mean, we're not getting terrible teaching evals, so we hope that means that the students feel like this point-counterpoint type approach or point-counterpoint is useful to them. But we don't really ultimately know, and it's not like we're doing longitudinal studies of our students to see kind of what they bring into their practice. Others are. We're not doing that with regard to our approach, but we're hoping for the best. It's somewhat anecdotal and not really kind of systemically studied. I think that, I don't know, do you want to say a few words about challenges?
And Layla, can we go to the next slide? I think the biggest challenge, or actually tension for me by trying to put all these arcs together, is that, on the one hand, we're saying be critical of the legal system, be critical of the legal profession. There's a lot of norms and practices that you see lawyers engage in that are important to question. And then at the same time, we're not saying we want you to pull back on the rigor and the skills training. In fact, we want you to pay a lot of attention to craft, and we want you to pay a lot of attention to how to be an effective advocate. And we want you to go and read all of this literature that's out there about how to be effective. We also want you, by the way, to pay a lot of attention to law office procedures and make sure you're logging your hours and saving documents on our files, electronic share drive. And so all of these things together, what I fear is that we could be sending mixed messages to our students. And I'm sure there's a way to reconcile all of this, but that is the tension that I feel. And I think that's why the quote that Sameer found about syncopation speaks to me so much, is because, you know, what we're trying to do doesn't really have a kind of clear single rhythm. It really is kind of a combination of different things that we hope students can come out of it more dynamic and more whole people and advocates. But it does put some onus on the students to do some reconciling of their own and some kind of reflection on who they want to be as professionals. So I think with that, and by the way, you know, even though there are some tensions and it is difficult to measure or really see exactly what students are taking away from this, we think that it is critically important. We haven't abandoned the effort, and it really is iterative and evolving from semester to semester. And so what we want to do now, we want to send you guys out into breakout sessions, and I think what we'll do is breakouts for maybe 10 minutes, and then that will give us some time to come back together for Q&A. So here are your instructions for the breakout sessions, and Layla, you can go to the next slide. Thank you. So what either Layla or Allison are going to break you up into small groups of about 5 people within each group. After you introduce yourselves, we want you to focus on these 3 questions. So the first one is, what are some of the justice education objectives you have for your clinic? In what ways are you seeking to push your students to think critically? They don't have to be in the same ways that Sameer and I have decided to push our students. Second, optimally, how else would you incorporate these objectives into your clinic seminar? And then third, what challenges are associated with trying to incorporate these objectives in a clinical setting and trying to connect them to the practice and the fieldwork? And what ideas do folks have for trying to address or resolve these tensions? So what's going to happen is that you will be broken out into these small groups in separate rooms. When you're in the rooms, you you will be unmuted, but if you want to mute your audio or video at any point, you can just click those buttons. You'll stay in these breakout rooms for about 10 minutes, and when it's almost time to come back, you'll get a warning. While you're in the room, you actually can't chat with us, so if you need help from Layla or Allison for a technical reason, just click the button that says Ask for Help, and that will allow you to chat with one of them. So when we come back, we're going to give you guys an opportunity to report back either through the chat box or by unmuting. We're going to unmute some people to give you a chance to report back and ask questions. So please identify a note taker for your breakout group who can be ready to share those takeaways. And you may wish to be jotting down in a separate document the takeaways so that you can quickly cut and paste them when we come back into the chat box, because you won't be able to do it from your breakout room. Okay? Thank you so much. See you soon.
Everyone, I'm going to be unmuting you shortly so that you'll be able to speak to one another in your groups.
Yeah, I just need to go check this. We need to go back to the prior slide. Okay, go ahead.
So yeah, we just wanted to see if in the small group conversations there were insights that you might have arrived at or shared with each other, or there were sort of challenges that we might share as a group together as we think about how to integrate a kind of justice arc in our curricula and in particularly our clinical syllabi. So I think the way to do this is if you have something to share from your group, please press the button that says raise your hand, and I think Allison or Layla will unmute you and you'll be able to participate in the discussion or share the insight or the challenge that might be worth some further discussion.
In addition, if people could type their small group takeaways into the chat box, what we're going to do is compile them and send them out to all the webinar participants along with a couple of the readings we mentioned today during the webinar after we end. So it would be wonderful, even if you decide you're not going to raise your hand and talk in this Q&A discussion session, if you could type your takeaways into the chat box so that we can compile them for future reference. Okay, so as people are deciding whether they want to raise their hands or putting their takeaways into the chat box, we're just going to talk a little bit about one tension that we have faced in our immigrant rights clinic with respect to teaching ethics that kind of builds on the tension that we identified earlier. We want our students to take the ethical rules and rules of professional responsibility seriously for a variety of reasons, including so that they can, and the clinic can continue the practice that we are engaging in without interference, but also want them to see the issue of professional responsibility rules itself as a form of furthering inequality and kind of reproducing some of the structures that keep our clients and the communities we work with marginalized.
So please feel free to interrupt us by raising your hand so you don't have to keep listening to our tired voices. And we'd love to hear anything from any of the groups or any individual thoughts that you might have about the topics that we've been talking about. But again, you know, the tension between teaching our students to be doing practical skills education, teaching them to be great lawyers within the box of legal practice as it's done now, versus the kind of critical counterpoint. Same thing applies with regard to ethics. There are a few concrete instances in which conflicts between the ethical rules and the kind of practice that at least some of our students engage in and that we all talk about over the course of the semester involve especially collaborations with organizers. So, you know, some of the rules that ethical rules that come into play when we're collaborating with organizers include client confidentiality and keeping confidences between the lawyer and the client, the dyad, as opposed to a much more complicated set of relationships that we aspire to have with organizers and family members and others who may be a part of the community that the client is from. And as well as the prohibition against third-party influence. Again, we don't see the lawyer-client relationship. It is a dyad according to the ethical rules, but in terms of in reality, we both the lawyer and the client are sort of in community, and we have lots of people on our end. Some of that is incorporated by the rules explicitly, and clients certainly have a lot of folks on their end, and you know, we're especially attuned to the potential participation of organizers and kind of participatory defense models like those advanced by Silicon Valley Debug and other visionary organizing groups around the country. And then, you know, the idea of unauthorized practice obviously is an important ethical constraint, and is one that we come across, particularly when we're doing Know Your Rights. You know, I think both of us would say that organizers we work with have deeper knowledge about the immigration legal system than we do in some cases. from their direct experience, from the experience of family members, from the experience of community members, from having to navigate that system, often without lawyers or without reliable points. You know, we have to ensure that we're in compliance with the rules while also empowering our partners to do the broadest degree of community education possible. So these are some of the dilemmas that we talk about with our students, and we find ways in which to approach, either through explicit writings that we might do in the form of an MOU with a partner group, or in a particular case, something we might do, for example, incorporating organizers as interpreters as a way in which to both comply with the rules while also allowing for a more complicated lawyer-client relationship.
I think that it's, in case some people can't find the raise your hand button on Zoom, let's try a different thing. Could we just, Layla, could we unmute everybody? And then if you want to speak, leave yourself unmuted. But if you don't want to speak, just mute yourself. And for those folks who are unmuted, we can call on you. Does anyone have a comment they want to share? Leave yourself unmuted. All right, so let's go to Caitlin Berry. Do you have something you want to share, Caitlin?
Hi, Sameer and Annie, this is so fantastic. I really enjoyed all of this. I couldn't participate in the small group because I don't have a mic on my computer. I couldn't get it to work. But I am thinking about this in the context of my incoming class. I just interviewed them for next semester, and almost all of them are very oriented to corporate law, are just taking a clinic because they have to, and don't seem to have much particular interest in the issues that impact our clients. And so if you have any words of wisdom for how to adjust my syllabus to meet them where they are, I'd love to hear it.
I mean, I think this is a chronic challenge that we face as well in this context in which we teach both together and separately, and that I'm sure many participants share. So thank you, Caitlin, for raising that as an issue. I mean, I think, as I said, I think in reference to in the race power context, the idea that excellent lawyering is both individual and it's systemic, and that applies in every context. I mean, one of the go-to things that we talk about when we talk about law and organizing is the fact that corporate lawyers have been engaged in really ethics challenging types of practice, both individual and systemic, much longer than community lawyering has existed as a category of public interest law. I don't know about longer, but certainly the same amount of time. That is, corporate lawyers have been challenging the bounds of practice, as a consequence of expanded, corporate client power, and their manipulation of the system and their ability to kind of game the system as it exists now. And so I think part of what we're trying to argue is that if you're going to do complex work and if you're going to have complex lawyer-client relationships, that prepares you for lots of different contexts, including, for better or for worse, contexts in which you may be representing clients who aren't grassroots organizers and communities. And the other thing I would say is deep fact investigation and community, like trying to get local knowledge, seems, again, essential to any kind of effective lawyering, including in corporate firm contexts. And that is attention to informal fact investigation, to how to organize facts, and fact families, in the words of Joe Lopez, thinking outside the box in terms of who might provide data about a problem or a challenge that your client faces. These, again, all feel like they are they cross practice areas.
So, and I would say I really appreciate that question, Caitlin. I think all of us struggle with it to some degree, and maybe different people to a different extent, depending on how your school's clinical program is structured and the types of students that come to your clinic. But what I guess what I would say is, one response to having a lot of students who kind of want to go into corporate or private practice is that you could shift your whole, like the messaging and your whole kind of clinic structure towards skills. And I think that's a mistake, and I think it's something we have resisted, even though we're at a school where our clinic is mandatory and our students do have to take our clinic regardless of what type of practice they want to go into. But that we have just made the decision to kind of retain the core of the justice education. And I guess that's for two reasons. So one is because we don't want them to see the practice we do in the immigrant rights clinic as either so different than, or it's simpler than, or maybe somehow less elite than the work that they're going to go on to do, and we want to show them the complexity of the work and how challenging it really is, and how it can translate to a variety of different contexts. But second, with respect to the parts of the justice education curriculum that I think help expose students to things like unequal access to resources, what it's like to live in an over-policed neighborhood, what it's like to be judged by a label or a rap sheet as opposed to the whole of the contributions as a human being. I think those feel universal, and whether they're going to go into corporate practice or some other intellectual property, that they have had some exposure to why the immigration system is structured the way it is, and why organizers and activists are
authentic teacher. They want to see teachers who are authentically themselves, and that might be harder for some of us because our authentic selves are out of accord with what they expect in a law teacher. But I guess the hope is that any student would would respond at least in some kind of constructive way to a passionate teacher. But I know that it's a little pie in the sky, but I'll put it out there.
Thanks for the question, Caitlin. All right, so I think maybe we have time for like one more question. Let's see, where are we? Maybe Sabrina Balgamala.
So some takeaways that we discussed in our group were related to exploring the attorney-client relationship in greater depth and the venues in which we practice. And we're very excited about the suggested readings as ways to bring those themes into our clinics.
Awesome, thanks, Sabrina.
Thank you. How about
Sheila?
How about Sheila Heyer? Sheila?
Maybe she's not there. You want to go to Amy Maldonado? This feels like talk radio. Amy Maldonado?
I'm here.
Did you have any comments or questions?
No, none at this time.
Awesome, thank you.
Thank you.
Great. Sure. Sabrina Rivera, are you there, Sabrina? Okay, then maybe I think we can sign off. We've taken up enough of your time. We really appreciate having this forum. We are especially appreciative to Layla and Allison for taking us through. The other thing we wanted to say is we wanted to pay a little bit of homage to people that have helped us. This is not an immaculate syllabus, right? This came from somewhere, and the two of us have each had teaching mentors who have kind of helped us develop a lot of this, and there's clear adaptations from other people's work. So I just wanted to mention Mike Wishney and Nancy Morowitz at NYU, who who I started teaching with and from whom I've adapted a lot of the stuff that I've used over the years, as well as at CUNY, Steve Zeidman in the Criminal Defender Clinic and Sue Bryant, who are both brilliant lawyers and brilliant teachers, and from whom I also copped a lot of this stuff. So I wanted to make sure that that I acknowledged them.
And I want to add to that list. I've worked also very closely with Mike Wishney, and I think he's really been a pioneer in kind of how we think about clinic dockets in particular, and the relationship between litigation and organizing, but also Munir Ahmed, who I had a chance to work with at Yale, as well as Jean Co-Peters, both of whom I just would not be who I am without them, and the teacher I am without them. So thank you all for joining us on what must be a busy day. We really appreciated being in community with you, and we hope that this is the beginning of a dialogue that we can continue after this webinar.
So I think we're turning it back to Allison and Layla.
Thanks, everyone. I don't think we have anything further. This is going to be posted on CLIA's Best Practices webinar page in a few days, and we really appreciate everyone taking time out of their day to participate. Thank you.